Hello, everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this Courthouse Steps Decision webinar on Corner Post Incorporated versus Board of Governors of the Federal Reserve System, featuring Professor John Duffy as moderator and Molly Nixon as our speaker. Professor Duffy is a professor of law at the University of Virginia Law School, and he and a colleague are working on a project on the Administrative Conference of the United States and filed an amicus brief. Molly Nixon is an attorney at the Pacific Legal Foundation, where she focuses on the separation of powers, and she also submitted an amicus brief in this case. If you'd like to learn more about today's moderator or speaker, their full bios can be viewed on our website. After our speaker gives her opening remark, we'll turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speaker, not the Federalist Society. With that, Professor Duffy, thank you for joining us today, and I'll hand things over to you.
Thank you very much. I teach administrative law and have written on it, and I think this is kind of an amazing issue because it has not arisen to the Supreme Court yet, and it was undecided, which is a very basic question of what's the general statute of limitations for an Administrative Procedure Act case. The Administrative Procedure Act is, of course, a very fundamental statute in administrative law. It's the most important statute, and a lot of challenges are brought under it. The issue of how late you can be or how long you have to file that challenge is something that, for a variety of historical reasons, took a long time to get to the Supreme Court. But it finally has gotten to the Supreme Court, and the Supreme Court has finally given us an answer in a 6-3 decision just this past week, or just a few days ago, as a matter of fact. I'm going to turn it over to Molly Nixon, who might just set the stage and answer some questions about this case. And we might just start out with just, give us the factual background of this case. How did this case arise, and why was the statute of limitations important in this case?
Sure. So to go back a little bit, how did this case arise? The underlying issue here was about the fees that a merchant has to pay when anyone pays their bill with a debit card. So the plaintiff here is Corner Post. It's a North Dakota truck stop, and whenever anyone pays them with a debit card, there is something called an interchange fee that goes to the issuing bank. Way back in, I believe, 2010, these fees were getting higher and higher. Credit cards had an incentive to charge higher and higher fees because that made the banks more likely to issue credit cards through the networks like Visa and MasterCard. So in Dodd-Frank, I believe in 2010, there was what became known as the Durbin Amendment, which directed the Fed to regulate those fees and come up with a reasonable maximum fee, which it did in 2011 through regulation that was called, I always think of it as Regulation 2, but I believe it's pronounced Regulation II. I've heard that a while back, so I'll go with it. Regulation II did cap the maximum fee that can be charged on a debit card transaction. I believe it's 21 cents, and then a 0.05% of the transaction. There was some initial litigation about that at the time, which we can go into later, but ultimately the regulation was upheld at the time. And Corner Post, the plaintiff here, came along, opened its doors in 2018, and sought to join a lawsuit challenging the regulation again on the grounds that it was arbitrary and capricious, and I believe not supported by the record. And the question that the court had to determine in the Eighth Circuit was whether this claim was time barred. There is a sort of default federal statute of limitations 28 U.S.C. 2401A that provides for a 6-year statute of limitations. And the question for the Supreme Court here was whether that 6 years starts to run from the time the regulation was issued. Here that would be 2011, or from the time that the plaintiff challenging the regulation suffers an injury and has a cause of action and can sue. And obviously that's outcome determinative here for Corner Post because they didn't exist during the whole time of the statute of limitations, which have been under 6 years from when the regulation was passed until 2017. But because they opened their doors in 2018 and started accepting debit cards then and started paying the fees then, they were well within the statute of limitations if it ran from the time they were first injured by the regulation.
So this regulation was challenged before and upheld in court. So, you know, what hope does Corner Post have, even if they get through the statute of limitations? How can they possibly challenge a regulation that the DC Circuit has upheld?
Yeah, you know, that's a question that I think goes to the answer to it might resolve some of the dissent in this case's concern, which is that, oh, we're going to have a massive glut of litigation. The DC Circuit, well, for one thing, the DC court initially, DDC, did say that the regulation violated the text of the Dodd-Frank Act, and that was overturned by the DC Circuit. Though I think the DC Circuit did require the Fed to clarify something on remand, but it wasn't vacated. So there were two opinions going both ways on this, on whether the regulation was a proper interpretation of the law. But yeah, so the analysis.
And they're not in the DC Circuit, right? They're out in.
Sorry, yes, they're in the 8th Circuit, and
they're in the 8th Circuit, so they're hoping to, a different court could split. The Supreme Court didn't uphold this regulation, so their view is we get our day in court. And we happen to get our day in court in the 8th Circuit, and they're not bound as a matter of precedent by any DC Circuit precedent. They might be persuaded by the reasoning of that court or not. So courts often split with each other. So that's their hope in this case. And if they can get past the statute of limitations, and as you said, it's a very easy calculation if you say the statute of limitations starts when they suffered their injury, because they didn't exist 6 years ago. So they could not have suffered an injury more than 6 years ago. So they're well within the statute of limitations. On the other end, if it's the government's view, this suit is like a decade old, a decade after the promulgation of the rule, then it's way more than 6 years. So it's a polar opposite positions here. So that's where we are. That's how the case gets teed up. Why did the Supreme Court take this case?
So there was, at least arguably, a circuit split here. Most circuits went with the 8th Circuit. And before I go on, I meant to say I should make my disclaimer that while my views are not those of the Federalist Society, they're also not those of the Pacific Legal Foundation. They're solely my own, just to get that out of the way. Put it in bold, and I totally forgot to say it. But yeah, so there was a circuit split here, or at least arguably so. Most of the circuits that had considered it, and I don't think it had gotten to all the circuits, but most of the circuits, including the 8th Circuit in this case, had adopted the government's analysis, which was that the statute of limitations runs from the date the regulation was issued. The 6th Circuit, in a case from 2015, I believe, took the opposite approach. There was some dispute in the briefing as to whether or not the 6th Circuit had actually ruled on the specific question here as to a facial challenge, or whether it was actually considering an as-applied challenge there. But it seems like for the Supreme Court's purposes, Justice Barrett says in a majority opinion, we took this to resolve a circuit split.
Right. That's right.
And it's a terribly, important one. to resolve for,
It would seem to come up in quite a few cases. And indeed, one of the things that was interesting to me, because I wrote this amicus brief, and it might actually explain some of the sort of fiery language, particularly in the dissent, is that the abortion pill case that's down in the, came from the Fifth Circuit, which the court ultimately dismissed before this decision on standing grounds. But that case did have this issue in it as well, because some of the things that were being challenged were years old, many, many years old. So the government, among the government's defenses, in addition to standing, was this very statute of limitations issue, saying just that the challenges to agency actions years ago was too late, because it doesn't matter whether the plaintiffs weren't born yet or whatever. It just, all that mattered is that the action is more than 6 years old. So it could come up in quite a few cases. Obviously, that case got decided on other grounds by the court, so we'll see what happens on that case. I think that case may be resolved with the court standing holding, but it can come up in a wide variety of contexts, it seems. So it is pretty important. There was a circuit split on this, as you said, the Sixth Circuit opinion in a case called Her, which I'm pretty sure was written by Judge Sutton, who's has I think a very strong reputation as a very good judge and a textualist judge. And I think if you read the opinion in that case, the case was called Her versus United States Forest Service. He basically really focused on the text of the statute of limitations, and I think that presages what the Supreme Court did. So we've got this battle now. We've got this statute. 28 U.S.C. 2401A. That's not part of the APA, to make that clear, correct?
That's correct. That's the sort of the default statute of limitations that applies to any suit that's not brought under a statute that has its own statute of limitations, or statute of repose, which a number of laws do have their own separate, much shorter limitations periods or periods of repose.
So yeah, so that distinction you just mentioned, I want to make that clear to our listeners here, or our viewers here. You just made a distinction between something called the statute of limitations and the statute of repose, and the majority opinion makes a lot about that distinction. And I wonder if you could summarize that, because I must say, I went to law school. Nobody ever mentioned a statute of repose versus statute of limitations distinction. So if you had told me a few years ago that there was this distinction, I would have been absolutely clueless as to what it was. So could you explain that distinction?
Yeah, I also, until it's possible I had heard of the distinction before digging into this case several months ago or a year ago. But I'm not sure about that. So I'm also a recent learner of this. But once I did learn about it and read it, a lot of this started to make more sense to me. And so the difference is, briefly, I guess, a statute of limitations is focused on the plaintiff and when the plaintiff suffers their injury. So it puts the onus on the plaintiff to move diligently in bringing their case once they have a case to bring.
I see.
And so if there is in this case, 6-year statute of limitations, the plaintiff has 6 years from when they have a case to get into court and bring it. Whereas a statute of repose is focused on the defendant. And there's generally a policy goal there of giving the defendant a relief from liability after a certain point. So it's and they're phrased differently. Statutes of limitation typically talk in terms of accrual when the cause of action accrues, whereas a statute of repose says a challenge can be brought within 30 days, 6 months, 10 years from when something happens. Not from when the cause of action, not from when a plaintiff has standing to sue, but from when something occurs. Here, it's the issuance of a regulation. And that's often the case in a lot of administrative law. You have 60 days to bring a petition for review of a number of different agency decisions. I believe Clean Water Act would be one of them. I know Magnuson-Stevens Act is a short one. It's 30 days from when a regulation is issued pursuant to that act.
Okay, so I understand that distinction. And just to be clear, I think it's always good to use examples outside of the field of law. So I teach torts too. Many times a repose statute and a statute of limitations might start running at the same time. If somebody runs me down with a car, the time the defendant's wrong is that day, and the time I suffer the injury is that day. On the other hand, you could imagine a tort suit where perhaps somebody pollutes land or something like that, and the pollutant is seeping across properties. And if you look to the time when the person's injury, that might be several years down the road from when the defendant, let's say, spilled some toxic waste. So then the time period as to when the plaintiff could bring a cause of action might be quite different than when the defendant did the action. And so some administrative law statutes, and one of the most famous ones, something called the Hobbs Act, says you have a certain number of days from the time the agency promulgates a rule. And you can tell that's a statute of repose because it looks at the defendant, which is the agency, and says that the clock starts ticking when the agency promulgates the rule. This statute doesn't do that. What does it say?
It does not do that, which is the basis for the majority's opinion here. And I'm just pulling up the express language so I can say it. It's every civil action commenced against the United States shall be barred unless the complaint is filed within 6 years after the right of action first accrues. So it's focused on the right of action, which is something that a plaintiff holds. The plaintiff has the right of action. And so it's 6 years from when they first start to hold it. And one other thing to add about statutes of limitation is that there are a number of other components that come into play, including when someone might not have a statute an injury until they know about it. So they might be injured and not know about it. And so typically a statute of limitations will start to run from when they have knowledge of their injury. There are also tolling periods that come into play. So if for Professor Duffy's example, if he was hit by a car and in a coma after that for several years, typically, I believe under a lot of states tort law, that you would have a tolling period, so the statute would start to run, or there'd be a period after the plaintiff is able to sue, when in which he could get to court. Whereas again, with statutes of repose, that's not the case. The focus is on giving the defendant an end date to potential court actions.
So this word accrue or accrues, which is in the statute, section 2401, is that an unusual word, or is that a word that Congress just used in this statute but doesn't use? It's very rare to see it, or is this a relatively common word?
It's a relatively common word, and the majority opinion, which is by Justice Amy Coney Barrett, does go into the court's precedent on what accrual means, dictionary definitions of accrual. She provides a definition for that. Let me see if I have it in front of me. Accrue has a well-settled meaning. A right accrues when it comes into existence. The dissent points out that there are a couple of other places, a couple of other definitions that even the majority uses, but they're all basically like that. And the majority does say, they come to their conclusion that the statute of limitations runs from the time when a plaintiff has a claim they can bring, based on a textual analysis and background principles and standards of law. But they do say that's what we're operating under when Congress hasn't specified otherwise. So she does, the majority does indicate, if Congress had said in this case accrues as something, a right of action starts to accrue as soon as the regulation is published for everyone, that's something Congress could do. They could also set, obviously a statute of repose instead. But applying the background principles of law and their understanding of the word accrue, it seems to be a fairly easy textual analysis. At least I was persuaded by the majority that it was fairly easy, and from the briefing as well.
Yeah, I think if Congress wanted to say it started, accrue means that it starts at the time the agency promulgates the rule, they could have said what they do in many other statutes, as you noted, and as the dissent notes, that in administrative law, statutes of repose are, often in statutes books and in various places. And then they do say that you have to bring the action, usually quite quickly, usually 60, 90 days, something like that, after the agency action has occurred. And that's, the sort of standard way. It would be a little odd to say that accrue, we're going to use the word accrue, but we're going to give it this meaning that means sort of the opposite of what it's normally used to. It's normally used to focus on the plaintiff, but we're going to instead focus on the defendant. It would seem a little odd. And I think in oral argument, the government could not come up with an example where, any statute, state or federal, had said, here's accrue, but we're going to give it this very, very different meaning. It just seems like it would be simpler to write the statute more directly the way many other federal statutes are written. And as you said, Congress does use statutes of repose fairly often in administrative law. And so what did the court make of that? I mean, one of the arguments that the government made is, well, because, a lot of statutes, when Congress thinks about APA actions, they often use statutes of repose. This background statute of limitations, which applies to all actions against the government, which, as you said, if they don't have another statute, why not interpret it in this context and say, well, it normally means accrue, but we're going to treat it as a statute of repose, because when Congress thinks about challenges to agency action, they really often use a statute of repose. That was one of the government's arguments. I hope I'm being fair to the government, but I think that's roughly their argument. Why didn't the court think that was persuasive?
That was the government's argument, and it kind of confused me, even just reading their briefs before oral argument, because I think that pointing to those other statutes is a really compelling way of showing that Congress must have meant something else here when they used different terms, and that's the approach that the court takes as well. Is it's fairly clear, and the government has pointed to a number of different statutes in which Congress demonstrates that it knows how to write a statute of repose. And it didn't do so here. There are some there was quite a bit of history to this what we call the default statute of limitations, 2401 A, which I probably could go into, but I'd probably get some things wrong there. And so I think that there were some arguments of perhaps Congress did not understand what it was doing when it made 2401A the default statute of limitations, and didn't realize that would apply to APA claims, which even for a couple of decades after that, I think, were governed more often in court by the concept of latches.
Yeah, it's a long and twisted history that Aditya Bamzai, my colleague, and I sort of gave the court an amicus brief that they cited actually in the sort of background section of the opinion about the history. I think our listeners might, think history's, that's water under the bridge at this point. It is really fascinating. It does help to explain why it took so long for this issue to reach the court. Prior to the 1970s, and this is something I find very interesting because of the involvement of then Professor Scalia in administrative law, professor at the University of Virginia, on leave to work in the government. And prior to 1976, you could not sue a government agency. In other words, this suit would be impossible because it was against the Board of Governors. You could only sue the officials, And that could give you all the relief you needed. You could just, sue the Board of Governors in their official capacity. And that was the way suits were normally brought against the government. And in that case, a statute like this, you wouldn't necessarily think that it was applicable because it governed suits against the United States. And the one thing you could not do is sue the United States or name the United States or even a subcomponent like the Board of Governors of the Federal Reserve Board. You could not do that. So you might not have thought that this was the default statute. And our history that we did said that to the extent the courts thought about this issue, they probably used latches. In other words, an equitable concept, because you were suing, usually you weren't suing for money damages, you were suing the officers for injunctive relief. So the courts naturally thought, well, if you sit too long on your rights, that's latches and you don't get equitable relief then. But when in mid-1970s, 1976, Congress amended the APA with testimony from the Department of Justice, and it was then Assistant Attorney General Antonin Scalia, to waive the sovereign immunity. And I think Justice Scalia or then Professor Scalia testified that this was kind of a trap for the unwary, and the Congress should just say sovereign immunity is waived in these cases because it really doesn't change anything. But then suddenly people could bring a suit just like this that names the Board of Governors. And then it makes a lot more sense to think that this general statute of limitations that applies to suits against the United States would be the applicable statute in an Administrative Procedure Act case. So that's, I think, where this, at least explains several decades of not having this issue arise. And then it did arise in the late 70s and 80s, and the courts did look to this statute, and then they began to develop a doctrine that they accepted the government's position that the most reasonable time to start the 6-year clock is just the time of the agency's action, rather than something else. And that was always sat uneasily with the text of this statute. But of course, that was in a different era. We're now in an era that cares a lot more about the text of statutes. And so this was, I think, something that was waiting to happen. One interesting argument that's raised by the government, which I think was not the government's main argument and was very subtly different, was that the statute says first accrues. And so maybe you should read the statute that the 6-year clock starts ticking as long as one plaintiff has standing to sue and has an accrued cause of action. And that would have been, in this case, more than a decade ago, because somebody did sue. Somebody did have standing, and it was right after the promulgation of this regulation. People had standing back then. People did sue. So I think the government could say, well, as long as some person had standing to sue, the cause of action first accrued to somebody, then that would be a good action. I think actually there was a very good law review article written by Professor Susan Morris at the University of Texas that I think really fleshed out this argument, maybe even better than the government's briefing did. And I think that was an attempt to reconcile something similar to the government's position, and it certainly would mean that the government would win in this case. There might be cases where nobody has standing to sue for some period of time, but those might be rare. Why did the court not go with that reading? It's kind of an aggregate accrual theory, sort of aggregate. As long as one person had standing and a cause of action accrued to one person, then it accrued for everybody. The time limit applies to everybody that same way. Why not that?
Yeah, and I do think that was the government's best effort at a textual argument, in my reading at least. And I also thought Professor Morse's argument there was very well done. And the majority rejects it because it says it is a slight misreading of the statute. It puts aside sort of the first accrues part of it and says, the statute speaks of a complaint filed within 6 years after the right of action first accrues. And it says, you know, that's the right of action in the complaint, and that, again, here it is plaintiff specific. If it had said a right of action 6 years after a right of action, that could be any plaintiff's right of action. And then that argument would be more persuasive. But the majority says that using the term the right of action is plaintiff specific.
Yeah, I think this is yet another example of how textualism, you know, completely different arguments are used with a textualist approach versus, let's say, a sort of policy-driven approach. A policy-driven approach would look to a lot of things that the dissent says. The majority, and I've got that page right in front of me, the majority italicizes the word "the complaint is filed 6 years after the right of action first accrues." And just the use of the definite article, which, you know, you might just read over if you're a law student or a sort of harried lawyer. Just the use of the definite article is important in the writing of this statute, because it, at least the majority believed, that slams the door on the government's kind of collective accrual theory. So that's the decision. I should say that we're getting some questions in the question and answer function, and they're to be expected. I think there's two people who've asked pretty much the same question, which is, there's another administrative law decision that came down in the last week or so that did something called overruling the Chevron doctrine. And so people on the question and answer are saying, gee, might this be related to that? Like, you know, if I, you know, previously thought an agency is going to be bulletproof under the Chevron doctrine, but now the Chevron doctrine doesn't exist anymore, so I can get de novo review of legal questions. Maybe as a plaintiff, challenging an agency action, I might rationally think that my odds might have gone up a little bit. So does this help? Does this revive a lot of challenges or create challenges to agency actions that, you know, happened, you know, more than 6 years ago, so maybe decades ago, when people thought, well, you know, that was a Chevron issue and I can't win on that, but now maybe I can win on that because there ain't no Chevron issues anymore. The Chevron is kind of dead and buried. What about that question?
I think it could. I think that these two decisions, while I'm not sure that the court really was focused on the effect, the dissents did, and I think it might be wrong, but I think in the Corner Post oral argument, it was perhaps Justice Jackson who said, you know, in a world without Chevron, and there was some media intrigue of, oh, does that mean that there is going to be a world without Chevron? Does the decision in Corner Post take on more weight?
Yeah, I do remember that, listening to the oral
Okay.
argument, which I did because I was very interested in this case, very interested in the Loper-Bright anti-Chevron case. And you know, the Loper-Bright argument had occurred a few weeks before this,
Right.
and then Justice Jackson said this in oral argument, and she used the past tense
Right.
to describe Chevron in a world where we did have Chevron. And you know, I think a lot of, you know, careful attorneys and people in the media suddenly realized, whoa, she used the past tense. She knows what the vote is on those cases. So is that significant? And then I think later in the oral argument, I think Justice Kagan chimed in and tried to sort of walk back the tense and be like, well, if there's a change to Chevron, but I think the sort of revealing the whole card had maybe been, you know, people had, you know, there's a tell in it. And we now know that Chevron did get voted to be overruled, and that is the world that we live in. So is this going to be significant that, you know, people could bring well, let's start with an easy case. I think an easy case. Let's say somebody challenged something and back in 2000s and they lost under Chevron. Does Corner Post help them?
I don't believe it would help them, the person who challenged law back then. If there, however, was someone newly affected, a new party or someone who's newly injured, yes. And there's a few different ways that it could come up. So I think this, I have to confess, I only read through the Loper, Bright, and Relentless decision quickly, but I've been obviously following it for a while. But I think that the court said, you know, the outcomes remain the same. So if the Supreme Court, and including in the Chevron case, that outcome is on solid grounds, regardless of the reasoning. So, you know, you'd be.
But if you had, let's say, a DC Circuit case
Right.
that deferred to an agency, and somebody says, you know, well, that's the DC Circuit, but it's not the Supreme Court. Why don't I just sue in the Eighth Circuit or the Fifth Circuit or somewhere else? Now, of course, I think you're absolutely right to say, if I lost a case or my client lost a case, they're going to be time barred because they obviously had standing to sue. They had an accrued action. They, in fact, acted on that accrued action. So they're going to be barred, but maybe they could root around in the industry and do exactly what happened in this case. Because actually, one of the real micro details of this case is this lawsuit started with some other plaintiffs who existed prior to more than 6 years ago, a trade association. And the government moved to dismiss this case on the ground of the 6-year statute of limitation. And lo and behold, Loper Bright joins the case. Corner Post joins the case. And Corner Post doesn't exist. So the argument then is, well, Corner Post, maybe the cause of action accrued for everybody else that previously was in this case, but not for Corner Post, because Corner Post is brand new. It's less than 6 years old as an entity. So you could imagine, not just imagine doing that seems very close to what's going on here. And the Loper Bright case does have some language that say, well, the old results are still protected by stare decisis. But I don't think the court is saying in Loper Bright that prior Chevron holdings get some sort of super stare decisis, that if you had a challenge to a regulation that got rejected in one circuit, that suddenly all circuits are going to be bound by that, even for plaintiffs that had no involvement in that case. So that, I think that it's, you know, this is a question that occurred to people listening, and I think it's a very serious question. It's a question that Justice Jackson remarked upon in oral argument. So it is, you know, for those of you listening who have clients who are lawyers and, you know, lost sometime in the past, that client's lost, but, you know, it might be an opportunity to seek new clients who are young clients, and young meaning, you know, recently incorporated. What about a corporation that is just like almost a shell corporation that just newly incorporates, you know, really to bring a challenge? Is that going to be an avenue that we might see a fair bit of litigation involving that kind of corporation?
I wouldn't be surprised if there is, for a time, a fair bit of litigation about that. I do think, though, that this is not something that courts will be in the dark in. I think that having to look at and determine whether there are manufactured plaintiffs or trying to get around the statute of limitations issues is not, that's not outside of court's expertise, whether it's, you know, predecessors or successors in interest or subsidiaries. These are things that courts have looked into and have analyzed and decided on for a while now. So I don't know exactly how that will play out going forward. And I think you're right, and I think the questioners are right, that there's a lot of interplay between these cases, and that if you on Friday you said, oh, there's this regulation that's just so clearly bad, and it was only deferred to on Chevron analysis in one circuit, and if I could just get it before a circuit, I think we'd have a good chance now. Then on Monday, the Supreme Court says, well, here you go. If you can,
Right.
if there's someone new here, you can bring that claim.
So an
That's
industry that has a lot of new entrants, that's like a dynamic industry, like this one. These are retail sellers who are all adversely affected by these, regulation or failure to regulate more stringently. So they all, it's an industry that includes lots of convenience stores and things like that, and the occupants of that change quite frequently. If you take maybe another industry, like let's say the automobile industry, there aren't new entrants into that every day of the week. So maybe that's harder to find somebody new to challenge some sort of longstanding regulation. But certainly it's something that lawyers should really think about in giving advice to clients. And it's not unknown that trade associations, I think, could fund litigation, agree to pick up the attorney's fees and things like that for a small business that, suddenly is new and has standing to do things. One of the things that I think is interesting about this is that the decision now requires these retrospective decisions about whether somebody could have sued years ago. And I think that's kind of interesting. It didn't come up in this case because the entity just simply didn't exist. So corporation is like, this is like at the time of suit, it was like a 4 or 5 year old, essentially, like, a toddler of a corporation. And so there was no question that it could not have sued because it did not exist. But you could imagine that somebody says, well, I was in the industry, but I wasn't doing this particular thing, or I wasn't involved in this activity, but now I am. I've moved into this business line. So I could not have sued 6 years ago, but I got standing in 2001 or 2021 when I moved into this field. And then the courts, it seems like, are going to have to do this analysis of, did you have standing back then years ago? Was the agency's action ripe? And the DC Circuit, in a similar context, had previously, again, this is lower court precedent on statutes of limitations, had previously expressed sort of a hesitancy to do any kind of retrospective analysis of whether somebody could sue. It's arguably dicta in the DC Circuit because they went through and did do such an analysis, but it may be that they're hesitant to do that. Do you think that they can keep that hesitancy, or they just have to dive in and look back and figure out when people could have sued?
Yeah, I confess I haven't thought about this a ton, but I think it's a really interesting question, because at least my initial thought is that yes, the courts will have to do that, and that the government, in these APA cases, a lot of times they're decided on the administrative record. There's not much discovery in them, except as to sometimes standing. The government will request discovery on whether your plaintiff is actually injured and has standing to sue, and so that chunk of discovery, I think, will be expanded now. It's very hard for me to predict, but potentially quite broadly, with the government.
And it's years ago. It's not
right.
When the complaint is filed, it's 6 years ago, 7 years ago.
Could you have sued? Were you potentially injured? That might involve a lot of invasive discovery requests for a corporation. I'm also not sure how it would apply to an individual. The government in the oral argument had brought up the possibility they talked about a dam that was permitted a couple decades ago, and they said, this, if you rule in favor of Corner Post, one of the parade of horribles examples they gave was someone who decides they want to see an endangered snail darter, that this dam is injured in some way. What is the relevant question there? What is the government going to ask of that person about what was in their head? When did they hear of the snail darters, 7 years ago or 3 years ago? And I don't know the answers to those questions, what the government's going to do and how the courts are going to resolve that. But I, like with anything else, I anticipate that this decision raises more questions the Supreme Court will ultimately have to answer.
So in that litigation, that hypothetical retrospective analysis, another interesting thing is the parties' positions are going to be reversed, right? Normally you see the government's like, you don't have standing, it's not right, no judicial review. And the private party saying, yes, I've got some tickets to go see I got airplane tickets to fly to this park, and I'm gonna, I got some plans to go. Instead, you're going to see the exact opposite. The government's going to be like, well, you at least thought about, we got some Google searches you did looking for airplane tickets to come to this dam and look at the snail darter, and that was back in 2015. So you had standing back in 2015. The other party's going to say, no, I never bought the tickets. It was just a lark. I really, didn't have any firm plans. So, the standing doctrine wouldn't do it. And so everything's going to be reversed in this retrospective analysis. It will at least be interesting to see the government suddenly finding lots of people have standing, with presumably not a lot of, with light showings. That will at least be, I don't know. I'll find that fun if I see those cases as an ad law teacher.
And you could see it also as a disincentive for a company, at least, to bring a lawsuit where the government's going to get that kind of discovery into, again, their financial records from 10 years previous to see if they perhaps were actually injured by a regulation that they now claim they weren't injured by until a certain date. That might limit some of that, or at least it's a consideration that potential plaintiffs won't take into before they bring a case.
And so they might look for a new entrant, and fund that litigations for, let's say, corner post type litigation.
One thing I did want to just make sure to mention, because we've talked a lot about statutes of repose and limitations and things that are now, regulations that might now be challenged that couldn't before, is that a point that Corner Post make a lot, and a lot of commentators made a lot, the majority discusses, is that there aren't regulations that were ever entirely free from challenge, in that even if you were barred from a facial challenge of the regulation by the statute of limitations, if the government enforced it against you, you could still challenge the constitutionality of that regulation, or whether it was authorized by the statute. So that's in terms of the whether there were decades worth of regulations that were etched in stone and could not be touched until today, and now they're all up for grabs again. It's not. It's not. It may be directionally what's going on, but it's not not accurate to the extent that every regulation was, or I shouldn't say every, but whenever someone was subject to enforcement, they could raise several of those challenges.
Right, that's right. There are even with statutes of repose, when the government comes and enforces it against you, you might very well be able to challenge the legality of the law that the government is enforcing. And by challenge the legality, I mean both constitutional and statutory challenges that say this was an invalid regulation or something like that. So that was, I think, a very good point on the part of the petitioner's counsel, the plaintiff's counsel in this case. They said, look, there's not a judicial review free zone that is protecting a lot of regulations. If the government wants to enforce regulations, it oftentimes has to defend their legality. One other interesting point is there's a footnote in this opinion, footnote 8, that says that was a big issue at oral argument, because at in the late briefing, I think it was the reply brief, and then at oral argument, the petitioner's counsel, the plaintiff's counsel said, well, some challenges might be off the table. Like if the government didn't give enough time for comment, or didn't give, committed some procedural error, the Corner Post counsel suggested, well, maybe we can't challenge that because we didn't exist then, so we wouldn't have standing to challenge that. Not that we're time barred, but just that we couldn't challenge something that's a pure procedural injury. The court drops a footnote and sort of says, maybe that's true, maybe it's not, we don't know. And but the Corner Post here definitely has some substantive challenges, and they can go forward. But it seems like there's a little bit of a punt there to, or kicking the can down the road, whatever metaphor you want to use. Is that, you think that's going to lead to some litigation?
I think it might. When I listened to oral argument, I was a bit confused about that. I'm not sure that there's a strong textual argument for distinguishing between procedural and substantive challenges of regulations. There are also some claims that it's not clear if I would consider, or at least I'm not sure if I would consider them procedural or substantive, like whether there's an insufficient record before the agency, or whether, presumably that's something like, I presume they were thinking about something like notice and comment. If you didn't exist and you couldn't comment, then perhaps you weren't injured by the lack of notice and comment, but you're still being injured by the regulation, presumably. So I'm not sure how that works, and I can see why the court said here we don't need to get into that.
Yeah, it's kind of an interesting footnote, because as a law professor, I often joke with students that, well, we're drawing the line between substance and procedure. And of course, that's a super clear line. Everybody knows that as a lawyer. It just says, oh, substance and procedure, that's, like night and day. It's very easy to distinguish. No, anybody who's a significant, anybody who's a skilled lawyer knows that's a very murky distinction. It comes up fairly often in the law, but it's often very, very difficult to draw. So I think that it wouldn't be a wild wager to suggest that that could be an area of future litigation. We have another question here from Warren Belmar, who is someone I know from work on the Administrative Conference of the United States. He asks, is the end result that challenges to regulations having the force of law can now be challenged to the same extent as challenges to laws passed by Congress? That's an interesting way of framing it. What do you think about that question? Is that one way to think about it?
I'm not sure. I think I'm not exactly sure what the question is getting at. Whether how the statute of limitations affects that. Again, with the fact that you could always challenge the constitutionality of a regulation if it was enforced against you.
I guess nobody, I mean, it's kind of, I think the answer to the question might be yes, that it's similar now, because, well, I suppose even this statute 2401 would apply if you, let's say, Congress passed a statute and you tried to, seek declaratory judgment relief 10 years after it's passed, and you could have sought it. You had standing to sue 10 years ago. I don't know of many cases that have barred constitutional claims on statute of limitations grounds. And certainly if the government comes and enforces it against you, you could always raise as a defense that the statute is unconstitutional. But as you pointed out, you could do that even before this ruling with regulations. You could say that regulation is unlawful, and that could be either unlawful on constitutional grounds or statutory grounds. So it probably is similar in that respect. We also have a question about what effect, if any, this decision will have on regulations that are subject to the statute of repose in the Hobbs Act, where there's like a 60-day time limit and you have 60 days to raise your claim, or else that statute kicks in. Does this tell us anything about that kind of cause of action?
I haven't thought about it or looked at it, but my initial reaction is that it doesn't, and I reserve the right to change my mind at some point, but my initial reaction is that it doesn't affect statutes of repose, because it is just looking at 2401A's accrual, the statute of limitations. It does, I should say, affect statutes beyond the APA. So that is the default statute of limitations. So it applies to, I believe, at least, I think I've seen the Endangered Species Act it falls, claims under the Endangered Species Act fall under 2401A. NEPA claims are brought pursuant, they're litigated under the APA. But so that same statute of limitations would apply. The Corner Post a decision here would affect those claims as well. But as far as actual statutes of repose, off the top of my head, I don't think this changes anything for them.
Yeah, I think that's right, though. I think there may be some dicta. I noticed some discussion about challenges after statute of repose had run, and some of it seemed to suggest that there were relatively broad rights there. I think it's pure dicta, but I think I think the answer to the question is there's not the holding of this case is not relevant to the Hobbs Act, but I think there may be some dicta that might be mined one way or the other in this case. One of the things that we only have a few minutes left here. One of the things that the majority in the dissent agreed upon was that the ball's in Congress's court. What did I mean by that? Majority explicitly said like, perhaps there would be that perhaps a solution that Congress might consider is to enact a distinct statute of limitations for the APA. So, and that's from the majority opinion, but they expressly cited the dissent and said, we agree that the ball's in Congress's court, as it always is, I guess, on statutory issues. But maybe this is something where we think Congress might actually act.
Amazingly, yes, which is I think good and potentially necessary here, depending on how it all plays out. I think the dissent's saying this is a disaster. This decision is a disaster for policy reasons, and so Congress must act. And the majority opinion is saying we're interpreting the text. If Congress wants something different, they are free to act. And I do think that there's room for Congress to act here. Again, this is a case about challenging a regulation, but the APA applies to all final agency actions, which goes far beyond regulations. And I could certainly see if the courts I'm not sure to the extent to which the dissent is right that courts will be flooded, but to the extent that there is a large uptick in cases being brought, things challenging, say, agency permits, again, like the dam issue or, a camping permit. I can't imagine a case would not be moot after 6 years, but I can think of some permitting decisions where Congress might want to say, a statute of repose makes more sense here. So even if they didn't say we're taking the entire APA out of 2401A statute of limitations, they might say for some agency actions or for certain agencies, we want to add a statute of repose, which is what they do for a number of the statutes EPA enforces. The Hobbs Act, again, that would not be a stretch or it's difficult for Congress to consider and work through where repose or a shorter statute of limitations or just maybe even a different a more specific definition of accrual could be useful. Or they could add more federal judges.
It will be interesting to see, and I will give a shout out to the Administrative Conference of the United States, which I'm working on a report with the DJ Bamza on this, and I think that the conference might very well consider making some recommendations about what options that Congress might consider in addressing some of the concerns that were voiced by the government in oral argument and by the dissent, by Justice Jackson's dissent in this case. Time will tell, but speaking of time, we are out of it. So it is 4 o'clock on the nose, according to my watch. So I will turn it back to the events programming here, and we will probably sign off, I believe.
Thank you so much to you both. On behalf of the Federalist Society, I want to thank you officially for the benefit of your time and expertise today. And thank you also to our audience for joining us. We greatly appreciate your participation. And you can check out our website, fedsoc.org, or follow us on social media platforms to stay up to date with announcements and upcoming webinars. Thanks once more for tuning in, and we are adjourned.